On that note, I get to introduce my guest to you. He is Tomiwa Fadeyi, and he is a legal practitioner. Thank you so much, Barrister, for being a part of the show this morning.
Thank you very much, Vivian, for having
Yes.
me on Breakfast Cafe this morning.
Yes, I'm so glad you're here. Now, let's hit the ground running, shall we? All right, so this is the first question.
Yes, please.
Yes, the first question I put out to you is this one. How does constitutional, or how will constitutional decisions shape the relationship between a government and the citizens?
Well, thank you for having me. Like I always say, the Constitution is of enormous impact, and that is in line with what you have said earlier when you were introducing the topic. The Constitution is literally the ground norm. It's what we refer to as the mother of all laws in Nigeria. That is to say that every activity that is legal, every law in itself derives its validity, right, from the Constitution. So anything that is inconsistent with the Constitution is null and void to the extent of those inconsistencies, and that includes even laws. So what I'm saying is that laws must derive their validity, the extent of their legality from the provisions of the Constitution. And they cannot, right, no matter how fantastic those laws are, they cannot be inconsistent with the provisions of the Constitution. It is the Constitution that provides for Nigeria being an indivisible sovereign state. It is the Constitution that provides for the tiers of government and the arms of government. As it stands today, we are expecting what will be a landmark decision of the Supreme Court of Nigeria in the suit which was filed by the Honorable Attorney General of the Federation, the erudite Prince Lateef Fagbemi SAN, on behalf of the federal government seeking for full autonomy for local governments. So we are expecting that decision today. That suit in itself is actually hinged. Let me put it that way. The suit in itself is hinged on the provisions of the Constitution that says that there should be a federal government, there should be a state government, and there should be a local government. The local government is the grassroots, is the closest to the people, right? So the local government must have its autonomy. I'm using this as an example because that is one of the issues that we are facing today.
Yes.
What you get is that many state governments, so to say, now exercise some sort of control over the local governments, and it is becoming appalling. It's almost like the local government is subsumed into the state government, which is not entirely encouraged, right? So even when you look at the way the Honorable Attorney General also made a suggestion, although I do not think that he has taken that to court, but he also made a suggestion stating that local government elections should be organized by the national body organizing elections in Nigeria, that is the Independent National Electoral Commission. This is because, as we know, apart from law, what is obtainable in Nigeria as of today, except in very few occasions, right? I do not want to generalize on TV, but except in very few occasions, what you get is that when there is a state, maybe that is being led by an APC governor or by an APC government, when there is a state that wants to conduct elections, you can be sure that almost all the local governments will go the way of the governor. You can be sure. You can be sure that there may be no elections. You can be sure that some governors will come in and then say, "Oh, everybody who is a local government chairman should excuse," and then appoint people they call caretaker chairmen. The question would now be, what laws, right? What laws do these governors derive these powers from, to declare caretaker chairman and all of that? Is it actually drawn from the Constitution? So these are things we expect the judgment of the Supreme Court, which will hopefully tell us where to go, that local governments should actually have some sort of autonomy over their finances and over their regulations. And that is what we are doing. So that is one of the major ways which the Constitution actually affects everyday life. I think these examples I've given shows how it affects the society and how it even goes into politics.
Perfect example. You gave the right one because it's on the front burner right now. In fact, what you said sparked a memory.
Yes.
Just last year, a local government chairman in Ogun State happened to speak up against his principal. He said the governor wasn't
Yes.
he wasn't doing what he needed to do, and then.
Yes.
The pressure began to be mounted on him, and it was as if they were going to kick him out of office. And then this particular local government chairman had to prostrate before the governor begging for forgiveness. That is not constitutional, is it?
No, it's not. Well, you see, the local government chairman you are talking about
Yes.
is Honorable Wale Adedayo of Ogun State.
Yes.
Yeah. And he's somebody that I've known him since childhood, right? You see, what happened in Ogun State is just the person involved, right, who is a journalist, is actually a public figure. I'm talking about the erstwhile local government chairman, I think is it Ijebu, somewhere in Ijebu, who was actually eventually suspended, right?
Yes.
You see, this suspension sparked, the matter is in court now. And I am aware that that local government chairman dragged the state government and the state governor to court. So the matter is in court, and so that may limit my comments on it.
Okay.
But when you look keenly at what happened, you see, we are happy that came out in the open, because some things are not, you don't get to wrap your head around it in Nigeria, right? Although the man said he didn't prostrate, but other local government chairman went and prostrated, and eventually that local government chairman who was tagged recalcitrant was suspended. I spoke up against it on a radio interview, and I said, look, these things cannot keep on happening this way. The governors cannot wield such power over the state and then over the local government. The local government chairman are heads of their local councils. Yeah. So they must have autonomy financially. What you get is that there are some things that should ordinarily be within the purview of the local government. They cannot even execute those projects because their monies are not with them. Some governors will just sit down somewhere and sign some particular amount of money for it's not done. That's not what the Constitution provides for, right? So these things they happen virtually everywhere in the country. Another example is the one I think happening in Rivers right now, the drama happening in Rivers right now.
Yes.
If you say that the tenure of local government chairmen has expired, it behoves on you to conduct an election. That is what I think. There is a time frame within which you should conduct that election. You see, these are constitutional issues. You do not just wake up and say, oh, your tenure is over, pack your load and go. After the State House of Assembly, because even in Rivers now, we wonder how many state houses of assemblies there are, right? But the State House of Assembly says we are extending the tenure of these people by 6 months so as to enable us to conduct an election. And then the governor says no. So you see, the varying decisions are just the lack of will to conform with the dictates of the Constitution. Lack of will to conduct. That's how I see it, and it is bad. That is why these constitutional issues have to go to court, right? It is provided for in the Constitution. So when they go to court, they are saying, please, court, interpret these provisions of the Constitution for us. So today, that's a major issue. It's on the front burner. That's why many people are expectant to know what the Supreme Court will say on this. So that suit which the Attorney General filed, the Honorable Attorney General, is a novel suit. It's a novel suit, and it's long overdue. That's why the man is being commended from many quarters. People have been saying that Prince Fagbemi having the courage to take such a matter to court is to liberate the local government, so to say, so that they can function optimally. Absolutely. Which was the intention of the draftsmen of the Constitution of the Federal Republic.
Very well said. You said in your opening statement that the local government is the closest to the grassroots, and you're very right. Now, one of the things you also said in your opening statement is the consistency of the Constitution. Now, at one point, does amendment coming? What leads to the need for the amendment of a Constitution?
Okay, well, the amendment of the Constitution is quite a procedure, right? It's quite a procedure, and this is something that just doesn't happen, right? You have to, an amendment of Constitution has several stages, right? For the places where there are lacunae in the Constitution, so to say, before you can amend, there has to be a bill to that effect. The bill must pass through certain stages, right? The bill must also, there's also a provision that two-third majority of the state houses of assembly must also conform. If I may relate this with the recent clamor for I'm sorry, I beg your pardon, for what they call regional government.
Yes.
I don't know if you've
Yes.
come across. There was a document that was there's a document that was flying about stating that there was a need for regional government and all of that. Those issues, so to say,
yes,
cannot come to play until the constitution is amended.
Okay.
Let me put it that way. Yes, until the constitution is amended, and that is the mistake that many people seem to make. Right? The law is the law until it is no more the law. So there's a thin line. There is jurisprudentially, there's a thin line between what the law is and what the law ought to be. You see, when many people are having discourse when it comes to legal affairs, what they say is, no, it shouldn't be this way, it is this way. Well, until it gets to that stage, right? Until it gets to that stage, it is still the law and it must be followed. Now, the mode of altering provisions of the Constitution is actually expressly provided for in Section 9 of that Constitution, right? Because we know that the drafters of the Constitution knew, envisaged that, as is the case with every other law, the Constitution is dynamic. Events will reveal, circumstances will reveal some loopholes in the Constitution. There's no perfect Constitution. But you know that our Constitution is a written Constitution, it's a rigid Constitution, it's not flexible. So these procedures must actually be followed. What it says, what Section 9 says, if I may just paraphrase, is that in either the House of National Assembly, the proposal for alteration of the Constitution must be supported by not less than two-thirds majority of all the members of that House. Okay. And it must be approved by the resolution of the House of Assembly of not less than two-thirds in all the states, right? What that means is that in the House where the amendment is supposed to take place, there must be a two-thirds majority support of that proposal to alter the Constitution. Right? The reason I don't want to, we all know that there's the first reading, there's the second reading, there's but because of our time, that procedure is quite lengthy.
Yes.
But two-thirds majority eventually must actually support the alteration of that Constitution. Then the houses of assemblies of the states, in all those houses of assembly, there must be two-thirds majority of all those houses of assembly to support that proposal, right? So the proposal must be approved by that number of people, by those number of people. And then that is where you can now say, oh, well, we want to alter the Constitution and all of that, right? Whatever bill there is, two-thirds majority in the House, then two-thirds majority of the state houses of assemblies. Well, I think that's a starting stage. That's the least you can have before you can then talk about, you want to. I mean, there are also stages where stakeholders, ideally, policy sake, there are also stages where stakeholders get to send in their suggestions, get to send in their own ideas in support or against the proposed alteration of the Constitution.
Very well said. Very well said. Now, this next question is very key, right? What role does constitutional courts play in protecting individual rights and liberty?
Constitutional courts actually, well, any court that is not constitutional is not a court. Let me just put it that way.
Okay.
So courts actually, the judiciary is what you describe as the last hope of a common man. Well, somebody argues that it's no longer the last hope of a common man. That is now the last hope of everybody. Because you see, even politicians who feel cheated run to court. Even the high and mighty who feel like they're about to be impeached run to court. So courts generally are, one mistake we shouldn't encourage is the resort to self-help. Okay. That is one thing we shouldn't encourage. If you feel, and in law we say that if there's an injury, then there is a redress to seek. Right? If you feel that your rights have been trumped on, if you feel that your rights has been sort of trounced, your own duty is to approach the court. The court is to give you justice. Now, there are different levels of courts provided for by the Constitution. There's the Federal High Court, there are the State High Court, there's the High Court of the FCT, there's the Court of Appeal, there's the Supreme Court. All of those courts, right, are in different hierarchies. But that is where jurisdiction comes to play, right? For instance, if your fundamental rights are being breached, you can institute a fundamental rights enforcement procedural action in a state high court or in the federal high court, depending on the nature of that breach. That's a jurisdictional issue, depending on the nature of that breach. So the courts are actually the one who, apart from the laws which we have in hard copies, like the Constitution, like what we call case laws, the laws actually is what the court says they are. The laws are what the court says they are. The interpretation of those laws as being done by the courts is what the law is. That is what sets the precedence for future actions.
Oh, wow.
Yes.
Wow, that's very deep. And it's interesting you brought this up, because one of the headlines on the major dailies, national dailies today, was that the CGN says there's going to be consequences for conflicting court orders. How do you handle this now? You said that an interpretation of the law is what the law is. So when you now have conflicting court orders, what happens? How do you handle that?
Well, that's quite a serious question. I was hoping you wouldn't ask that, because even I was hoping you would ask that, because even we lawyers are at loss as to some of the things that are happening. The CJN made that statement yesterday at the swearing in of the new judges, I think into the Court of Appeal and other. You see, and the CJN, that particular statement is not just a bark, it's a bite, right? One of the key issues that warranted that statement is what happened in Kano.
Yes.
The Ganduje Bayero saga.
Yes.
Right? And you see, it's just rather unfortunate, right, that different decisions, conflicting decisions, a court will say black, and then another court, sometimes of concurrent jurisdiction or coordinate jurisdiction, would say white. You see, it's difficult to handle, but what we encourage is that our courts must not allow themselves to be used as a political tool by the politicians. It shouldn't be allowed. There are some things that you see, these courts are sacred temples of justice, right? These courts are the ones that actually said, the courts are the ones maintaining the fabric of this country by the decisions. Because when there is a law and there is no sanction, then that does not complete that law. Before you can say that this is a law, there must be a sanction attached. Now, it is the courts that will impose those sanctions. It is the courts that will interpret those laws. It is not right. It is not correct. And when this has to do with something that affects the fabric of our profession, the fabric of our society, we must speak up. It is not right that a court will give a decision and another court will sit on it, that same issue, and give a conflicting decision. Especially court of coordinate or concurrent jurisdiction, right? What is obtainable is that when a court, and many of these things are caused by litigants. This is not to shift the bulk of the blame, but many of these are caused by litigants. If you go to a court and a decision is given against you, the duty that behoves on you, that is why the Constitution provides for an appeal. You have a constitutional right to go on appeal. If the State High Court delivers a judgment against me, I'll approach the Court of Appeal. I will not go and approach another State High Court in another state rather. I won't, if the High Court in Lagos delivers a judgment against me, I won't go to Oyo to go and file that action in another High Court. It's an abuse of court process and it should be condemned. That is why in many courts now, you have to swear to an affidavit of non-multiplicity of actions. That is, you will state that this action you are instituting, you have never instituted it before another court. You have to do that now. If the State High Court in Lagos State delivers a judgment against you, why not go to the Court of Appeal and ask the Court of Appeal to set aside that judgment and allow you appeal? That is the procedure provided for by law.
Wow.
That's the procedure provided for by law. So I know that the CJN actually sanctioned some of those judges, the CJN and the Judicial Commission, actually sanctioned some of those judges who delivered conflicting judgments. They called them, and I think there's a panel set up to trash that out. But I think that should serve as a deterrent, because that may lead to total breakdown of law and order. If somebody is waiving the judgment of a state high court and somebody is waiving the judgment of a federal high court, and they are saying, no, I have this judgment, you are deposed, you are not deposed, and I think it may lead to some sort of anarchy that we do not want, that we shouldn't encourage.
Oh, wow. Now, on a final note, as we wrap this up now, for the case of, okay, just for the purpose of clarity, you said something about politicians not interfering with the rule of law. So what is the relationship between constitutional decisions and political decisions or political power? Few seconds as we wrap this up.
Well, like I said earlier at the beginning of the program, any decision or any power must derive its validity from the Constitution. Whatever, but I don't exactly know what you are referring to as political power, but any decision must get its validity from the Constitution. Any sort of political power, any sort of political decision that is inconsistent with the provisions of the Constitution will be null and void to the extent of that inconsistency.
You know, I'm sorry, but I have to. But
decision.
I'm sorry.
Yes,
I'm sorry. I have to come in here. We are bringing you back for a part 2. I'm telling you. But we've run out of time, and we have to go now. Thank you so much.
Thank you very much.
Yes. I appreciate you. Thank you so much. All right. So we have been speaking with Tomiwa Fadeyi. He is a legal practitioner, and we've been taking a look at the impact of constitutional decisions on society and politics.